please join us on camera? Thank you. The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today. We are hearing arguments today in several cases, and now is the time set for the appeal and cross appeal in McFarland versus McFarland. Counsel, if you would please enter your appearances for the record.
Morning, Your Honors. Jacob Cowden for the appellant, Bruce McFarland.
Angeli Dockich on behalf of the cross appellant, Nicole Jensen, formerly known as McFarland.
Thank you, counsel. We have been conducting our arguments virtually for the past little while, and things have gone pretty smoothly. The one thing I would mention to both of you is that I don't know if you've argued with this court before, but during the time where you are not arguing, if you could please turn off your cameras and mute your microphones, that will allow us to focus on the individual who is making the arguments. We will also try and keep our microphones muted unless we have a question. And so if you sort of see us, motion or move around a little bit, we'll try and interrupt you or not interrupt you, but try to get your attention to let you know that we have a question. Otherwise, we'll keep our microphones muted as well. Both sides have 15 minutes in which to make their argument. Because there is a cross appeal, I understand that you have both reserved 5 minutes for rebuttal to address address the arguments on each of your cross appeal. We'll start with Mr. Cowden first, then we'll go to Ms. Dockich, and then we'll give you each your time for rebuttal again. So do either of you have any questions as we proceed?
No, Your Honor.
Well, thank you. If there is a problem, with your video, your sound, anything like that, please try and let us know as soon as possible. And if there is a problem, obviously we'll get it corrected and we'll give you whatever time you need, and don't stress about any of that. We haven't really had too many problems, but just let us know if something happens that does cause a problem. Thank you. Mr. Cowden, you can begin anytime.
All right. Waiting for that formal approval, Your Honor. Thank you. I appreciate the opportunity to argue for the court today, and I guess it'd be prudent to start out with just a very, very short history of this case. These parties married in 1992, divorced in 2009, and the factual circumstances of this case kind of caused some confusion with application of different portions of Utah law. What had happened is after the parties divorced in February 2009, the respondent, Nicole, was awarded the marital home. However, she wasn't making the mortgage payments, at least that was the allegation at trial. And after some time, my client, Bruce, moved back into that home in April of 2009, so just 2 months later, and Nicole had moved back out. And what had happened in that circumstance is my client had not paid alimony other than just the single payment in January via the mortgage. And in moving back in the home, he assumed sole care of their 4 children. From April 2009 until September 2009, those were the circumstances. Although the decree awarded the home to Nicole, it was my client, Bruce, that was actually in control of the home, paying the mortgage, taking care of the upkeep and paying all utilities, as well as providing sole care for the children. September 2009 comes, and the parties actually reconciled for a period of time. Nicole moves back into the home, and that reconciliation continues from September 2009 until April of 2010, when Nicole moves out and actually enlists in the military. From April 2010 through and until the current date, there's no dispute that Bruce McFarland has been providing sole care for the parties' children, and also residing in the marital home and taking care of all the mortgage payments and the upkeep of the home. So Of course, there's more factual details there, Your Honors, that I'm happy to address, but for the court, that is essentially the facts that lay the foundation for the issues we're disputing. My client raises two issues, Your Honor, on appeal. The first issue being that of the alimony award. At the time the decree was entered, alimony was set at $1,700 per month per paragraph 10 of the decree. And as the court can imagine, it raises this issue of cohabitation given the facts that I've just cited. The parties did cohabitate in September of 2009. That fact does not appear to be genuinely disputed. The court found in paragraph 23 of the findings of fact that the parties had met a lot of those criteria for cohabitation. They shared an intimate relationship. They shared expenses. They operated. Yes, please.
Which version of the alimony statute are we to apply here?
Thank you, Your Honor. Both argument at trial as well as the finding from the trial court was that the version from 2017 should apply, Your Honor. And so that version, the court is, I guess, referencing the amendment that later occurred. Later, I think it was at some point after the 2017 petition, the amendment by the legislature was to provide a limitation on trying to terminate alimony if the party did not file for that termination within 1 year after. Yes, Your Honor.
Yeah, I'm asking not just because of the 1 year limitation that the legislature added after the fact that I think all parties now agree doesn't apply here. I'm asking because it seems to me that if we're applying the 2017 version of the statute, that's the same version of the statute that the Utah Supreme Court applied in Scott. And I guess I'm wondering why the Scott case applying the same statute, interpreting the same statute, doesn't foreclose your claim here. Under Scott, you would have had to move for cohabitation, move to terminate alimony on the basis of cohabitation during the period of cohabitation based on the version of the statute that was in effect at the time that required establishment while you have to establish that the spouse is cohabiting. And I guess, I'm confused as to why Scott doesn't just completely foreclose your appellate claim on this question. And I'd like to hear from you on that point.
Thank you, Your Honor. Yeah, the Scott decision also came after this petition to modify, and that's really the best argument that we have is the statute at the time the petition was filed. And more so, Your Honor, the circumstances that we're citing here, the facts we're citing also predate not just the Scott decision, but also the facts in Scott. This cohabitation occurred in 2009 into 2010. So even the facts themselves greatly predate that Scott decision. And that's why we would ask, obviously, that the statute for the 2017 form of 30-35 or 5, subsection 10 apply. And further, that the Scott decision is not necessarily in play just yet, or at least shouldn't apply to this circumstance.
But aren't judicial decisions sort of retroactive by their very nature? I mean, what the Supreme Court is doing is interpreting what the statute means. And, the statute will have always meant that for the entire time that it has included the language that the court is interpreting. And it seems like once you acknowledge that the statute in Scott that the court was interpreting there is the same statute that is at issue here, it seems like the analysis in Scott has to apply here, doesn't it? I mean, am I missing something?
Your Honor, certainly the legal standard is applicable as such, where the party in that case did not file right away. It was not within that 1 year period, and that's why the court set that precedence. And further, that segued into the amendment to the statute itself. And so, that is a difficult position for my client to address. But the point being, Your Honor, where the facts greatly predate those same facts and that same interpretation. And if you apply the statute in this case, dependent on that statute, that version in 2017, that would be, I guess, the best argument. Further, Your Honor, there's this confusion with that statute saying that any order of the court that a party pay alimony to a former spouse terminates upon establishment by the party paying alimony that a former spouse is cohabitating with another person. And this case also unique and different from Scott in the fact that the parties were the cohabitants after the fact. My client is, of course, arguing that as far as cohabitation is concerned, it could be any person. And the statute just says another person. It doesn't limit it to another person other than the parties to the case or to the petitioner himself or the respondent herself. So if the recipient spouse is cohabitating with anyone, any other person, that would result in the termination of alimony. And that's what should happen prospectively moving forward, such that there's no arrears, that it's just dead as of that time and date. And Your Honor, I would plan to move on and use my remaining time on that second issue unless you have more questions I can address. Thank you. As to the second issue for the court, there's the concern with the child support calculation. And this one's a little difficult because the issues that were certified were to address non-payment of child support and a few other issues that were raised through a motion for order to show cause. And my client had filed a petition to modify, but that had not quite been certified for hearing before the court. The interesting thing about that, Your Honor, is the decree awards Nicole the child support each month to be paid by my client. Of course, as I've stated, my client became solely responsible for these children as of April 2009. There's this brief period where the parties share care for the children, arguably while they're cohabitating from September 2009 to April 10. But from April of 2010 forward, my client's providing sole care, yet the decree of divorce has not modified. It still awards Nicole the child support obligation. And we've cited repeatedly and leaned heavily on the statute, Utah Code 78B12, Section 108, that obligations ordered for child support and medical expenses are for the use and benefit of the child and shall follow the child. Your Honor, I would just cite that there's no dispute that Bruce McFarland has provided sole care for these children. There are cases where it's complicated. You have the second part of that statute that addresses joint physical custody and that automatic change. I would argue that second subsection of the statute does not limit. Yes, Your Honor.
How do you make it retroactive as far back as you're attempting to do here? Is that by case law? Is that a statute you're looking at? Isn't there actually a statutory problem with making it retroactive under these facts?
Yes, Your Honor. Yeah, so Utah Code 78B, Chapter 12, Section 114, subsection 4, does mention that a party cannot modify a support obligation retroactive prior to the date a petition to modify is served. We're arguing that that particular statute, as well as the statute I just cited, Section 108 of the child support section, they butt heads in the sense that child support should follow the child. You have, in this case, is probably one of the best examples you'll find of that conflict, Your Honor, where you have a parent. Yes.
108 doesn't actually mention modifications, does it?
Does not.
How does that then butt heads with a statutory provision that expressly references modification?
Well, the essence of the statute, Your Honor, is it's the plain language. Child support should follow the children. And if you have a situation where modification should occur, yet it hasn't, you do not have child support following the children. And again,
Well,
yes, Your Honor.
Maybe I'm looking at a different version of the statute, but it looks to me like the statute says that the support follows the child, quote, without the need to modify the order, unquote.
So that second part of the section, Your Honor, that addresses a limited situation where you have a sole custody calculation that can simply switch. And to me, it might be a little outdated in the sense that there's not as many cases where you have sole custody that can just automatically switch. In fact, most cases now, including recent bills coming up that suggest and encourage joint custody, that this language does not capture those type of situations. And this particular case, Your Honor, you have a joint custody case on paper that was truly sole custody. And we have the benefit of a child support worksheet that was filed at the time of trial where we already have a child support calculation as though Mr. McFarland's providing sole care for the children. It'd be $328 per month.
So maybe I misunderstand, but I thought you were relying on Section 2, subsection 2.
Section 1, Your Honor. So subsection 1 states that child support shall follow the child. Subsection 2 then gets into an automatic modification in a very limited factual circumstance. It doesn't address all factual circumstances, including, again, most joint custody cases. And Your Honor, if you look at that statute.
So your argument for affirmance is that we should apply subsection 1 and should determine that subsection 2 is inapplicable here.
Not necessarily, Your Honor, because subsection 2, again, applies to a limited factual circumstance. It's not addressing other factual circumstances, such as a change from joint to sole or sole to joint. And the language in subsection 2 does not limit. It doesn't put a box around those issues. It just addresses this one factual circumstance of sole custody. So even the intro language to subsection 2, Your Honor, says, except in cases of joint physical custody and split custody. It does not go further and say in those cases you cannot automatically modify.
But the trial court determined, and I think the trial court may have been right on this point, that we were never talking about joint custody in this case. The joint custody is defined statutorily in terms of overnights, and in this case, your client always had sole physical custody. So we were to the extent subsection 2 represents an exception for cases involving joint physical custody. The trial court determined that exception wouldn't apply here because we never had joint physical custody. And I thought you were sort of tracking that argument that the trial court had sort of bought off on. But today you seem to be backing away from that argument and asking us just to apply subsection 1 rather than subsection 2. And I guess I'm a little confused.
And the confusion stems from the facts, Your Honor. The fact being that the decree calls for a joint custody calculation. It sets out numbers for a sole custody calculation as though Nicole, the respondent, is the sole custodian. But that changed, 2 months after the decree was entered, and it flopped. Now, if that initial calculation was done with Ms. McFarland having sole custody, yes, we could just cite subsection 2 and swap that calculation. But what happened is the parties did a deviation on child support as though there were a joint custody calculation. And that creates the factual confusion there, Your Honor. So you're right, and you're right again. There are those two aspects to it. If you cite the February 2nd, 2009 child support worksheet and say, look, this was the actual support calculation, we could have an easy switch. We could just switch that. It would go from support to Nicole to support to my client. But there's that little fact in there that kind of makes that a little difficult to apply subsection 2, where the decree goes further and says there's a deviation to child support. We're going to calculate based on joint custody, even though that wasn't necessarily the case.
Okay, so your argument, your argument today for affirmance is grounded solely in subsection 1, not subsection 2.
We have an issue with just citing subsection 2, Your Honor, because the decree calls for a joint custody calculation. Although we would appreciate an affirmance based on saying this is sole custody and we would like to just switch that under the sole custody calculation. I think we have to embrace the fact that that joint custody calculation did occur in the decree. And, equitable argument, ultimately, that these kids were supported by Bruce McFarland for a decade, more than a decade now, and that if child support were to follow the child, we would follow that sole custody calculation in Bruce's favor. And I've gone way over the time. We've asked questions.
I have another question, but I have another question, but I don't want to interrupt Judge Mortensen, who had his hand up a second ago.
My question's simple. I guess I'm misreading it. You're saying, you've said 3 times now that the deviation was that there was a joint custody calculation. I thought it was actually the opposite. I thought the decree actually awards joint custody, but that the deviation was that even though it was joint, it awarded Mrs. McFarland the child support as if she were had sole custody, so that was the deviation. Do I have that wrong?
I misspoke as to the child support versus the custody.
Because
yes,
the decree awards joint custody, right?
Right. Yes, but paragraph 8 calculates it on a sole custody worksheet. So I appreciate that, Your Honor, because that really simplifies, I guess, what I've been trying to say, but in a really horrible way, is that where that sole custody calculation occurs, per the decree, you could just switch that under subsection 2. And again, there is a February 2nd, 2009 sole custody worksheet that sets out what the child support should be. So we could cite that under subsection 2. The issue being is the joint physical custody award within the decree. So in either way, Your Honor, my client's been providing sole custody care for these children, and child support should follow the children in that same vein.
My final question to you, and I know you're over time, is that there seem to be 2 components to this child support issue. Number one, you seem to be, at trial, your client seemed to be arguing simply defensively. Your client was basically saying, I shouldn't owe Nicole child support for these many years, but your client seemed to stop short at trial, and the trial court understood your client's claim this way, to stop short of asking that the payments be reversed and go the other way. Up here on appeal now, you're asking for both of those things. You're asking us to affirm the court's decision that Bruce doesn't owe Nicole any money for child support, but you're also asking us to reverse the court's decision and go a step further than the court did and ask to reverse and have payments go the other way. And I'd like you to address the court's basis, the basis upon which the court refused to do that for you. The court refused to do that for you on the basis that he didn't think you were asking for that. And that's in conclusion, I think 13 of the trial court's rulings. And I'd like you, if you have it at your fingertips, can you point us to any place in the record below where you actually asked the trial court offensively for affirmative payments running your way, as opposed to just defensively, I don't owe her any money?
A fair point, Your Honor. When I started the argument, I brought attention to the fact that the motion for order to show cause was truly the only certified item before the trial court. My client did have a pending petition to modify that did include affirmative requests for that modification of child support. But the trial court, Your Honor, while they should have, theoretically stuck within those contempt issues, there was the stepping into these modification issues. The House, which I'm sure we'll get into, is a prime example of that. But in the findings of fact, Your Honor, you do see the court address the arguments and address it purely as contempt. And yes, we are asking that the court uphold at least that provision where the court says, hey, I'm not going to award child support arrears, because truly, in essence, those were the certified issues. However, the evidence presented at trial did go well beyond that. It went to my client providing sole care, my client requesting that. However, we can't deny the petition to modify was not properly certified, which was the affirmative request that would have led to asking for that properly, I suppose.
Well, I don't even read your petition to modify that broadly. Your petition to modify seems to ask for child support going your way going forward. But I don't see anywhere in your petition to modify even where you ask for child support going your way retroactively, and the court certainly didn't understand it that way. And so coming to the point here, generally people can't ask us for relief that they haven't first asked the trial court for, right? That's an unpreserved issue. Right. And the trial court disposed of your affirmative claim for relief on that basis. And if I guess I'm just giving you an opportunity, since you've raised it in your appellate briefs, even though it may be unpreserved, I just want to give you an opportunity to point out to us here, if you know of any place in the record where you actually did ask for affirmative retroactive child support payments going your way.
And I appreciate that opportunity, Your Honor. So in the record at 386, it's the petition to modify paragraph 3, and that's the affirmative request for relief, Your Honor. And this is the child support provision, record 386, Your Honor, just if you have that. It says petitioner should be awarded child support and maintenance of the party's children. Cites the children. Petitioner has had the children in his custody since September 2008. Responded out of the military after the party's divorce was finalized in 2009. Goes on, paragraph 5, it kind of repeats again, should be awarded child support for the maintenance and figures pursuant to, and then it cites the statute. So, there is that in the petition to modify, but again, the petition to modify wasn't certified. The evidence, it's difficult because the evidence presented did step into that issue. I believe there's arguments in trial briefing that touch on that as well. But the trial court, you're correct, the trial court in the findings did not address that affirmative relief and only addressed the request for arrears, and essentially stopped at saying the arrears don't need to be paid at this time. Did not go further.
So I think I found the document you're referring to. It's the original petition to modify. There was an amended petition to modify also.
Right.
But you're citing, I think, to the original one, paragraph 3, petitioner should be awarded child support for the support and maintenance of the party's minor children. And you're only naming the 2 who are still minors at the time of the petition. And it appears to be a going forward request that starting in 2017, your client gets child support payments coming his way going forward. I still don't read that as a request going all the way back to 2010, I guess it would be, for your client to get some sort of arrears payments from Nicole. And the trial court, I think, understood it that way too. And anyway, that's the way I see it. And if you think I'm getting that wrong, please let me know.
Well, and it's a fair point, Your Honor, that while I wish it was a clean request, retroactive, including all 4 children, that paragraph does also cite the custody wards as of 2009. Not too much or difficult of an inference to suppose that request should go backwards to the date where Mr. McFarland took over care of the children. But as far as citation goes, other than the evidence that was presented, when we talk about the certification and that providing the grounds for this appeal based on the judge's decision, that is what we would refer to. I appreciate you letting me go over time and addressing the court's questions. Is there anything else I can answer? Thank you.
Doesn't appear so. Thank you, Mr. Cowden. Ms. Dockich.
Honorable Justices, may it please the court. The current order of the court is that there is an alimony arrear award of $150,744.50. This was not made in error. There are several issues to address here. As far as the party's actual decree, it's paragraph 10, where Bruce was ordered to pay Nicole alimony in the amount of $1,700 per month. He only ever made one payment. Even prior to him moving into the home, he had only ever made one payment. Furthermore, the decree specifically says that it's to continuing until Nicole remarries, cohabits, or dies. And so as we've set forth in our briefing, it's a bit of a matter of first impression as far as Utah courts, but there's already been a decision that's been in effect for nearly 30 years or around 30 years from out of the courts of Illinois. And that's the Antonich decision that specifies that a person has to cohabit with someone other than them. The opposing party would have to cohabit with someone other than themselves, the former spouse who's a party to the action, especially when there's a support obligation such as alimony. Yes, Justice Harris.
I guess I'm curious why you're not. There's feedback. I'm hearing that feedback. Is that you, Ms. Dockich? I don't know. I guess I'm curious why you're not hopping on the Scott v. Scott train and you're jumping to Antonich, which applied a non-textualist analysis that I think would make our Supreme Court's heads explode. So tell me why. I quizzed Mr. Cowden about Scott v. Scott, which when I read Scott, and everybody seems to agree that 2017, the 2017 version of the alimony statute is the one we should apply here. Scott's dispositive, regardless of what the another person says, it seems to me. And I guess I wonder why you're not hopping on that train a little more stridently than you are. I mean, you do kind of make the argument at page, I think it's 21 of your brief.
Well, I'm addressing that as well.
Isn't that argument? Go ahead.
Oh, yes, Your Honor. I think you're right. And maybe I should put that argument first because it would foreclose that claim. And it's our position that it does foreclose Bruce's claim regarding alimony and his allegation of it being in error. Certainly, he didn't move to modify while he was cohabitating. Furthermore, as far as the law to be applied, this court has held that it's the law at the time the issue is adjudicated. So that means certainly Scott would in fact apply. That's supported by the Garza versus Burnett case, Harper versus the Virginia Department of Taxation. You would apply the law when it's being adjudicated. So certainly Scott would be the applicable law. So I think you're right, Your Honor, but we're also trying to, I guess, suggest to the court that provision of law is lacking in Utah. For one to say that they themselves can cohabit. Specifically, the court in this case, the trial court, found in the findings of fact and conclusions of law that one cannot cohabitate with themselves. And so essentially a party to the case who has that support obligation cannot be the one that then again cohabits with their former spouse. Again, I think I'm jumping to Antonich because even though it's persuasive authority, it's directly on point basically in the court's analysis and the way in which the courts have laid out, and the Illinois court laid out, that you essentially can't cohabit. It's kind of the same argument that the trial court concluded that you can't cohabit with yourself. And as far as you being a party to the action, otherwise it's going to set bad precedent. Every ex-spouse who has an alimony obligation would be trying to then cohabit for any small period of time just to avoid their alimony obligation. Is that a hand?
If you want to go to the Antonich path, then here would be my question. The way you've quoted Antonich to us on page 19 of your brief, the Illinois court said this: the proper interpretation of a statute cannot always be based on its language alone. It must be grounded on the nature, object, and consequences that would result from construing it one way or another. The primary inquiry is to ascertain the legislative intention, not only from the language used, but also from the reason and necessity for the act, the evils sought to be remedied, and the objects and purposes sought to be obtained. That's the Antonich analysis. And then we pick up Scott, where our Supreme Court says that we have to start from the premise that we should discern what the legislature intended from the plain language of the text, unencumbered by notions of what we think the legislature must have wanted the language to accomplish. I mean, our Supreme Court's looking just at the text. And if you look at just the text of another person, wouldn't another person include the former spouse?
No, because what our Supreme Court is looking at is also the intention. I mean, I respectfully disagree with this statement you've just made. I think that they're still looking at a statutory interpretation. And even though Antonich says it as statutory interpretation and common sense, the Utah court is still concerned about the legislative intent. They're saying, what did the legislature intend here? So they are looking at the actual terms of the statute, but at the same time, they are saying, what is that intent behind it? And so I don't think that the Utah court, I mean, the way that the statute is written, if you are looking at the plain language, the Utah court doesn't spell it out. The Utah legislature, doesn't spell it out and say one can't cohabit with a former spouse, but it doesn't say cohabit with anyone. In fact, the Utah statute says that you must cohabit with another. And another would be another other than the other party. That's what the language on its face looks like, because it does specify with another. And I would argue, and we do argue, it's our position, Bruce is not another when he's the party to the action. Another means someone other than Bruce himself. Again, I think if you're looking at the actual language and statutory interpretation, it's something where maybe we do need a bit more direction by this court. Maybe we can set that precedent. And that's what we would ask this court to do, or at least give us some guidance with statutory interpretation, because they are looking at the legislative intent. The Utah courts are looking at that. They are concerned about that, although they are looking at the plain language of the statute. And again, I would not assume that it would be that the legislative intent, and as we've argued, is not to say that any former spouse could come back to the marital home or try to reconcile for any short period of time, just to avoid that alimony obligation. And so furthermore, what's also important is the installments of support become vested when they are due. So that means all of the months from the time that the initial decree was entered in February 2009 going forward, those payments have already vested. So that's something that's different, where it's something that's already due and they can't go back on that. Only prospective alimony or modification of alimony is proper, as set forth in the Bernard case. And so again, Utah law supports that maybe there should be a modification. I mean, in this case, it's not really relevant because Nicole had already remarried, and we acknowledge that in our briefing. And so from that date of when she remarried, that was the time in which the trial court in this case said that's the cutoff date for alimony, according to the party's decree, according to statutory law, and what the Utah courts have found. And so again, that alimony award was not in error. In fact, we believe, and as we've argued, the court got that part of the decision correct. And it's something that really, again, I do point to the Scott case. I mean, we did argue it. I know that the court acknowledged we have a small portion of our argument in our briefing about the Scott case, and we did set forth that point that it would foreclose anyway because Bruce didn't move in 2009 to modify or to terminate his alimony at that time. And when he sat on his rights, he should not be able to come in now and try to claim that retrospectively. Furthermore, as far as the issue of the child support, so I wanted to just clarify for the court, although it was the sole custody worksheet that was used, it was an upward deviation because it was essentially the amount that was calculated there divided in half. And then that's what would have been awarded to Nicole. The issue that we take with the child support is that the parties entered this agreement when they were already operating on a sole custody type schedule where Nicole was providing the care for the children during the day and when they would get out of school and in the evenings. But then for the actual overnights, the children were sleeping at the marital home. So part of the time that was with Nicole. Obviously, when she joined the military, that was solely with Bruce, and that was in 2010, April of 2010. And so from that point going forward, yes, Bruce had the sole physical custody, but under statutory law, Utah law says it's based on the number of overnights. So where the parties already had this arrangement in place at the time of the decree, where Nicole would be the one to watch the children during the days, on the weekends, in the evenings, but they were spending the nights in the marital home, whether that be with Nicole or Bruce, that wouldn't change the obligation going forward. And again, we initially, again, we cite to our argument in our briefing about the obligation being vested at the time the support is due. And so even at the time before Bruce moved back into the home after the decree had entered, he had only ever paid Nicole 3 months worth of child support. And so he didn't support the children going forward at that time, but there is no dispute. I mean, we acknowledge that when she joined the military, it was impossible for her to exercise the the joint physical custody.
Ms. Dodds,
yes.
could I just ask you a quick question about the timing? I think I misunderstood a little bit. Did you get 5 extra minutes because there's a cross appeal, correct?
That is correct.
And so now your time has run on your response time to the regular appeal, and I think you're going into your rebuttal time in that respect, or into your time, your 20 minutes. So I just wanted to. Do we need to reset the clock at 10 minutes? Are you?
No, I just have 2 more points to make, really, really briefly, if I may.
Yes, but then I think you're going into your other time.
Okay, I can reserve 3 minutes off that time then if I need to.
Okay, thank you.
I know sorry, just to address your inquiry, I know there's rebuttal time for the appellant appellant as well, but I know that he had also gone over his time. So I'll just wrap this up very quickly.
Okay, thank you.
Thank you. And so we've set forth our argument regarding the child support, and we feel that there needs to be additional guidance by the court as far as what the trial court's decision was regarding child support. And then very lastly, our last point was about the marital home. The main issue that we take is that it was in fact a certified issue, certified on January 11th of 2019. In the findings of fact and conclusions, the court did make some decisions about the home, but then reserved final adjudication. So again, we just feel that was something that was certified and should have been decided, and I'll submit on that. Oh, yes.
What's the relief that you want us to give on that particular issue, right? The trial court seemed to indicate that he was aware of the issue, but that he didn't think it was teed up for him at that particular time, that he made a temporary ruling and that further proceedings would ensue. So if we were to tell him, yeah, you should have decided this, please decide it, he's going to go, well, I already am. it's already on my tick list of things to do, right? So what is it that you want us to do with regard to that issue that you think will actually help, given that the trial court does seem to be aware of the issue and just seems to think that it's going to decide it down the road?
Well, we do believe that it was properly certified at the time of the trial, and we did include evidence, testimony, everything in trial about the marital home. And so, again, on remand, we would ask for direction to move forward and adjudicate that issue as it should have been previously adjudicated. And I'll submit on that. I'll reserve any remaining time. Thank you.
Thank you. For the court, just again on this alimony issue, the Scott decision, again, being what it is, I think that one thing that counsel doesn't address, or that is a factual concern, is the fact that the cohabitation is another person. It's my client. It's not Nicole. It's also an interesting issue to say that the cohabitation is with the ex-spouse themselves. I don't know of any case law that addresses that specific circumstance. The concern and the difficulty with that is if you begin to cohabitate with an ex-spouse, whether or not you need to file a modification during the relationship, almost sort of that awkward postnuptial agreement in some sense. And so where it is another person that Nicole is in fact cohabitating with, it just happens to be Mr. McFarland, that the statute at the time did not prohibit or place a time limit on that. And there's no discussion as to that specific ex-spouse issue, that there should be a termination of that alimony obligation such that there's no arrears and there would be no judgment. On the child support issue, I think that at a minimum, the district court got this right. The trial court was correct to deny the child support award, not necessarily citing this, but almost sort of equitable argument that there's no doubt, there's no factual dispute that Bruce McFarland provided sole care for these children. That's been stated. It's not disputed on trial. It's found by the court at trial that that's correct and true. And therefore, there's really nothing else there to discuss other than potentially this affirmative request for child support that my client is seeking, whether by way of the appeal now or by way of the petition to modify that I suppose remains pending before the district court. Again, it was never certified. Does the court have any questions on those two issues? I don't want to repeat anything I've already said, and I'm ready to move on to just briefly address the marital home. Thank you. As to the marital home, the trial court made an interesting decision in the sense that there was a denial of the request for relief under a contempt analysis. That relief requested by Nicole was denied. However, the court went a step further and awarded the home on a temporary basis to Mr. McFarland. That temporary award tends to fall under a petition to modify type approach, where it would be a Rule 106, Utah Rules of Civil Procedure, Rule 106, ratification of an agreement. So my client has possessed the home since April of 2009, continues to possess that same marital home. It's where he's raising these children that he's cared for. And that temporary award is the standing order of the court. Our position is that whether or not there is a remand on this issue, that after this appeal is concluded, there will need to be a certification of my client's petition to modify, as he's alleged, to address that formal and final award of the home in his favor. Because at best, he's got a temporary award per the trial court's decision. And so it is an interesting issue that's been created by the trial court's decision, in that it wasn't simply a denial of of Nicole's relief, but a step further, that award of temporary possession of the home to my client. So I don't know that we necessarily take strong issue with the remand, in the sense that it's going to have to go back before the trial court anyway to address long-term possession that follows that award, that temporary possession award. I've done my best to be very succinct, because I know I went over time on my initial argument, but does the court have any questions for me? I'll submit on the rest, Your Honors. Thank you so much.
And Mr. Cowden, are you going to plan to, Ms. Dockich has time to argue the cross appeal. Do you feel like you need any rebuttal time?
I would just reserve that a little bit.
Maybe a few minutes.
Yeah, just trying to be efficient, I suppose.
Thank you.
Thank you.
And Ms. Dockich, we'll give you your 10 minutes. Oh, sorry. Oh, 5 minutes. I'm sorry. 5 minutes.
Thank you, Justice Foster. So I'll just reiterate once again, we do believe that Scott forecloses on the appellate claim regarding alimony because Bruce did not move or file his petition to modify it while he was cohabitating with Nicole. For him to now come in after the fact, 9 years later, more than 9 years later, to try to make that argument fails under current law, that Scott would be the current applicable law there, it makes the issue moot, essentially. And again, just to reiterate, Bruce had flat out told Nicole he wasn't going to pay her alimony. And he said he wouldn't pay her alimony, and he didn't intend to. He didn't intend to pay her child support, and he didn't. And he wanted to completely reverse the court's order as far as the marital home. Again, that's something where we might get some direction on, but it must. It's essentially reserved for another time for the court to adjudicate on the home. But overall, it's Bruce not liking the court's final decision and what was ordered in their decree of divorce. And so in a vigilante kind of way, he went ahead and has been successful up to this point in absconding the orders of the decree and not being compliant with the decree. And certainly that's not legislative intent. It's not what's supported in the statutes. In fact, UCA 30-3-5, subsection 10A, it specifies in order to be relieved of your alimony obligation, the other party would have to cohabit with another. Bruce is simply not another. The court did not err. The court got it right in saying that one cannot cohabit with themselves. That's also supported in the case of Myers versus Myers, 266 Pacific 3rd, 806. And that's the Utah Supreme Court 2011 case. And so there is recent law about that. There is recent law saying that one must cohabit with another. And certainly the legislative intent is not the other being the former spouse who has that support obligation. And I'll submit on that.
I didn't hear much argument regarding the marital home. I plan to reserve my time to address that after there was additional argument. My only point to add to that marital home issue, if that's what I'm limited to, is just the fact that the trial court found that Nicole hadn't taken any steps under the decree to really vest her right into the home. Paragraph 20 of the court's conclusions of law detail how she did not assume the mortgage, she didn't pay a lien, she didn't begin paying mortgage payments, and she otherwise took no steps to assume the obligations required by the decree. And essentially is deferred to my client to possess that home and be responsible for it. And
but are you required to vest when the decree awards you that possession as part of the divorce decree? Are you really required to vest something that has been awarded to you? Aren't you arguing more of like sort of an estoppel, or, you know, that she basically forwent her possession? You don't have to vest something that's you already possess, do you?
Yeah, and the trial court's conclusions of law, you know, I guess to be fair, there's a really interesting circumstance again here where there is this award of the home, but it's also coupled with all of these other obligations. And the court essentially saying, look, can't just take the home and not also assume all these obligations that are set out by the decree. It's you know, if the decree is to be followed strictly, then there wouldn't be this issue at all. And instead, of course, the court's cited where I would go is the equitable estoppel argument. By her actions and by the passage of time, she's all but conceded to this position where the petitioner, my client Bruce, is now in possession of that home. And that's really the conclusion that the court gets to. And the procedural aspects of that really complicate it further. Again, where this was presented to the trial court by way of a contempt proceeding, whether or not my client is in contempt for not permitting possession of the home and possessing the home himself. And the court giving that temporary award of the home just really shows that there was that certification issue, whether the entire circumstance regarding the house was properly presented to the trial court for a full and final decision, where the trial court could say, I'm going to deny contempt. I'm also going to go further and make these modifications to the decree to address all of the pending issues. And so that another factual complication with this case, Your Honor. But you're correct. Not necessarily a vesting issue, but certainly something where you have the award, but you also have assuming the loan, making the mortgage payment, paying a lien, paying the utilities, managing the upkeep. She didn't do any of that. And that's why you get that decision from the trial court, which we asked the appellate court to uphold. Appreciate your time. Thank you so much.
Ms. Dockage, did you finish what you wanted, or do you need just a few more minutes to?
Just a couple minutes for final rebuttal. So some new issues were raised about the home, and I realized that it would be a direction about adjudication on that issue, but the issues are so interrelated that they should have been decided together. The home certainly was already awarded to Nicole. There shouldn't have to be something where she's already got the vested interest. She shouldn't have to take additional action. By Bruce not paying her alimony award, she wasn't able to afford the mortgage. She certainly didn't let it go into foreclosure. I've stated in the facts and at trial, if there was ever a foreclosure, it was when Bruce was there. It's nothing she was aware of. Again, he refinanced the home in his own name without permission and without modification of the decree or the award from the court. So again, this is Bruce acting on his own and defying the court orders that are in fact in place. He doesn't want to pay alimony or child support. He doesn't want to pay anything, and in fact wanted to get back into the home and take that away from Nicole as well. So everything that was awarded to Nicole, Bruce essentially took from her. He's figured out a way here to reverse the entire order in his favor, even though it's not in alignment with the decree. If Nicole was paid the child support she was owed, if she was paid the alimony she was owed, there would have been a completely different outcome. And Nicole did ask Bruce to leave the home multiple times, and he refused. He instead moved his brother into the home. He moved his girlfriend and her children into the home. He just took over the home as if it had been awarded to him, when all this time it was actually already awarded to Nicole. And so that's something, again, where we need to move forward and have the court address this. Any issues that might go down on remand should address in an interrelated way with the home, just so that we don't get deadlocked again in a decision where the court has difficulty moving forward. And that's what we ask this court for, is for direction on that, and essentially that the court that the court that the court uphold and affirm the district court's decision as far as the alimony award, and give us further guidance and direction on the other issues before the court. And I'll submit on that.
Thank you, counsel. And Mr. Cowden, if you wouldn't mind coming back just quickly, we will, and you as well, Ms. Dockage. We will thank you for your arguments today. We'll take this matter under advisement and render a written decision as soon as we are able. And I think unless there is anything else that my colleagues, either questions or anything else, we will be in recess until our next argument. And I think Ms. Dockage, are you appearing in the next hearing as well?
Yes, I am.
Okay, so we'll see you in just a minute.
I'm sorry, am I able to stay in this session, or I need to re-log in?
Yes, you'll have a new invitation in just a second.
Thank you.
You're welcome.
Thank you, counsel.